Every year in South Carolina, thousands of projects begin the same way: land, equipment, and a plan to build or produce. Agriculture and construction depend on one shared reality. Once you disturb the ground, you assume responsibility for what's beneath it. That responsibility is the foundation of South Carolina's Underground Facility Damage Prevention Act, commonly known as the 811 Law. In 2025, the General Assembly passed House Bill 3571, also called Act 65, updating how that law works. Those updates take effect May 22, 2026. The intended purpose of Act 65 is not to slow projects down. It's to reduce utility damage, service outages, safety incidents, and costly delays caused by miscommunication before digging ever begins. The updated laws place greater emphasis on planning, coordination, and clearly defined responsibilities. This is especially true on larger or phased projects where multiple crews may be involved. Under Act 65, South Carolina clarified and expanded key legal definitions, including what qualifies as proper notice, when excavation is considered to have officially started, how large projects are handled, and how damage must be reported. For example, under the updated law, excavation isn't just when heavy equipment hits the ground. If you work on side jobs, a homeowner, or just a weekend warrior, trenching for drainage, or installing irrigation after a ticket has expired or the scope has changed, that can now be considered non-compliant excavation. The update makes clear that notice must match the actual work being performed, not just the original plan. Previously, the law focused heavily on the act of notification itself. The updated statute, however, focuses more directly on the process, how notice, marking, excavation, and reporting connect from start to finish. Excavators are still required to contact South Carolina 811 and provide at least 3 full working days notice before digging. What changes is the expectation of coordination, particularly when projects evolve, expand, or extend beyond the original scope. For farmers, Act 65 reinforces that when conditions in the field don't match what is expected, work should pause and communication should happen before digging continues. That might mean calling 811 again when irrigation trenches move outside the original plan, when drainage work extends farther than anticipated, or when previously unknown lines or conflicts appear. The update makes clear that continuing to dig when the situation has changed can shift responsibility, even when that work feels routine. For developers and landowners, this means every site evaluation matters more. The law reinforces the need to identify potential conflicts before ground disturbance begins, not after. Failure to follow the updated process can result in stopped work, civil penalties, liability for damage, and responsibility for repair costs, even when the damage itself was unintentional. On large or multi-phase projects, Act 65 makes clear that a single notice does not automatically cover evolving work. Planning and documentation must match the scale and duration of the project. That means general contractors, developers, and project managers must ensure subcontractors understand new notice is required, and when work must pause until coordination is complete. The law shifts responsibility upstream. Oversight is no longer passive. Those directing the work are expected to verify compliance, not assume it. With an effective date of May 22, 2026, the countdown has already begun. Waiting until permits are issued or equipment arrives is too late to adjust procedures. For farmers, the law applies just as clearly. Irrigation installation, drainage work, fence posts, tile systems, and trenching all qualify as excavation under South Carolina law. Act 65 encourages early communication, especially when agricultural work intersects with utilities, drainage systems, or future development plans. The intent is not enforcement for its own sake. It is prevention. Fewer strikes, fewer shutdowns, and fewer disputes over who was responsible. When planning and notice are done correctly, work continues, efficiently and safely. The same principle applies on construction sites. Verify, document, coordinate, then proceed. Act 65 works best when everyone, owners, contractors, subs, and operators, share the same understanding of the process. The law does not stop progress, it protects it. But it does add additional procedural checks that, if ignored, can lead to delays, penalties, and even costly liability. Under Act 65, excavation isn't just about moving dirt. It's about following a documented process. When compliance is built into planning from the beginning, projects don't move slower. They move more reliably. Clear expectations, shared responsibility, and early coordination allow teams to handle challenges without stopping work. House Bill 3571, Act 65 of 2025, takes effect May 22, 2026. Update your procedures, educate your teams, and ensure subcontractors clearly understand when work must pause. For farmers, this includes irrigation, drainage, trenching, and fence installation. The 811 system is a strong foundation, but consistency and oversight matter, especially on large, fast-moving projects. South Carolina is growing fast. Doing this work right today helps avoid bigger costs tomorrow. Always contact South Carolina 811 before you dig.